Precisely. It's not an either. It's a story of potential energy just waiting for the right spark.
I also want to mention the senior lips effect from the reading. This felt like a real statistical gut punch to anyone who trusts the fossil record blindly.
It's a sobering concept. It basically says that since fossilization is so rare, the last fossil you find of a species is almost certainly not the last individual that actually lived.
And the first one isn't the first one.
And conversely, the first fossil you find is not the first individual that lived. Things exist for a long time before they get lucky enough to fall into the right kind of mud and turn to stone.
So the sudden appearance of trilobites might just be the moment their population density got high enough to finally get caught in the fossil lottery.
Exactly. It smears the dates. But even with all these caveats, even if there was a long fuse, the consensus is still that the Cambrian was a unique time of rapid innovation. You can't have a long fuse, but the bang was still a bang. The disparity we see in the Burgess Shale, that's real.
I want to circle back to that weirdness before we close, because there's a philosophical point that Stephen Jay Gould made in his book Wonderful Life that I find really haunting. The idea of rewinding the tape.
This is Gould's most famous thought experiment. He looked at the Burgess Shale, at Opabenia, at Wawaxia, at Hallucigenia, and he saw all these disparate body plans. And many of them just died out. They have no living descendants. Opabenia is gone. Anomalocaris is gone.
We don't have five-eyed nozzle beasts today.
I do not. We have arthropods, insects, crabs. We have chordates, us, fish, birds. We have mollusks, clams, squid. And Gould asked, if you could rewind the tape of life to the Cambrian, just start the movie over from 538 million years ago and press play again, would the same winners emerge?
And his argument was no.
He argued for contingency, that survival was largely luck. Maybe a mudslide happened a mile to the left. Maybe the oxygen dropped for a week. Maybe a predator turned left instead of right. If Pikaia, our little worm-like ancestor with the primitive notochord, if it had been in the wrong place at the wrong time and gone extinct, the entire vertebrate lineage never happens.
That is the heavy part. Pikaia is not impressive to look at. It just looks like a confused little eel.
It's tiny, but it had the precursor to a backbone. And if that one lineage gets wiped out in the Cambrian lottery, then no fish, no dinosaurs, no mammals, no humans, no deep dive podcasts.
We might be the intelligent descendants of Opabenia right now, arguing about that weird two-eyed fossil called Pikaia that went extinct. We'd be communicating by waving our nozzles.
A frightening thought, but scientifically plausible under Gould's view. Now, to be fair, not everyone agrees with Gould. Simon Conway Morris, who also worked on the Burgess Shale, he argues for convergence.
That's the idea that evolution inevitably finds the best solutions.
Right. He argues that eyes are a good solution, so eyes will evolve. Intelligence is a good solution, so intelligence will evolve. Even if Pikaia died, something else might have evolved a backbone, because a backbone is a great way to swim and support a body. But even if you believe that, the specific weirdness of the Cambrian shows us just how broad the possibilities were.
It was a moment where the biological rulebook hadn't been written yet. And that brings us to the legacy of this event. Because even though Opabenia is gone, the Cambrian explosion basically set the table for the rest of history.
It did. By the end of the Cambrian, almost every major phylum, the broadest categories of animal life, was established. We haven't really invented a new body plan since then. Nature settled on the winners. And for the last 500 million years, it's just been riffing on those themes.
Just variations on a theme. A slightly better beetle, a slightly smarter ape. But the chassis was built in the Cambrian.
Correct. The blueprint of your body, bilateral symmetry, a head at the front, a gut running through the middle, a nervous system, the pairing of limbs, all of that was codified in the mud of the Cambrian Ocean.
It is just bizarre to think that when we look at ourselves in the mirror, we're looking at a design that was battle-tested against Anomalocaris.
We are the descendants of the survivors, the ones that swam fast enough, burrowed deep enough, or built hard enough shells. We are the legacy of that first great arms race.
So here's the takeaway for you. The world we live in, this green, loud, complex world of animals, is not the default setting for Earth. For about 85% of Earth's history, life meant slime. Life meant quiet mats of bacteria. The Cambrian explosion was that singularity where the universe, on this planet at least, suddenly became aware of itself, started hunting itself, and started seeing itself.
And the fact that we are here to talk about it is a testament to the incredible and incredibly fragile chain of events that started 538 million years ago.
It makes you look at the world differently. Next time you see a worm on the sidewalk or you eat a shrimp cocktail, show a little respect. You're looking at the veterans of the greatest war in biological history.
Couldn't have said it better.
Thanks for taking this deep dive with us. Stay curious, and we'll catch you on the next one. Welcome back to the Deep Dive. Our mission is to take stacks of complex sources, articles, research, historical archives, and give you the ultimate shortcut to fluency. Today, we are undertaking a deep, analytical examination of the International Court of Justice, often called the World Court.
It's an institution that's, well, it's defined by its paradox, really. Our sources detail the ICJ's immense legal authority as the principal judicial organ of the United Nations, a body capable of settling profound legal disputes between sovereign states. Yet, at the same time, we have to grapple with the fundamental operational truth. The court is, functionally powerless when faced with political resistance.
Our goal for you today is not just to understand what the ICJ does, but why it matters, and maybe more importantly, why it often fails to deliver tangible justice despite its position. And before we unpack that tension, we have to clear up the single biggest point of confusion for absolutely everyone.
That's the geographical and functional twin problem in The Hague. You, the listener, need to know this distinction clearly. The International Court of Justice, the ICJ, which we are discussing today, sits in the Peace Palace in The Hague, Netherlands. Its mandate is narrow but powerful, resolving legal disputes exclusively between states.
So, State A versus State B, that's the ICJ.
Correct. It is not the International Criminal Court, the ICC. The ICC is also located in The Hague, but it operates under a different treaty, the Rome Statute, and its function is to prosecute individuals, presidents, warlords, generals, for things like genocide, war crimes, and crimes against humanity.
Got it. So one handles disputes between nations.
And the other handles criminal accountability for individuals. We are focused squarely on the ICJ.
So we're looking at the ultimate global legal referee for sovereign nations. And this isn't some modern invention. This body, established in 1945, is built on decades of prior attempts to create international justice.
That's right. When the ICJ was officially established in June 1945 by the UN Charter, it was. It was succeeding the defunct institution of the League of Nations. It really represented the culmination of a half-century-long quest for global legal order.
And every single one of the 193 UN member states is automatically a party to its statute.
Exactly, which makes its reach potentially universal, even if its actual authority is, well, it's limited.
Okay, let's unpack this. If we're tracing the DNA of the ICJ, we have to go back to the 19th century, right? To the first formal attempts at global dispute resolution.
We begin in 1899 with the Permanent Court of Arbitration, the PCA. This emerged from the Hague Peace Conference, an idea initiated by Tsar Nicholas II. It was a groundbreaking move, establishing a framework for arbitration between states. The core concept here was that legal mechanisms, not just war, could resolve international conflict.
But the name, the Permanent Court of Arbitration, is a little misleading when you compare to the ICJ today, isn't it?
Absolutely. It wasn't a standing court in the modern judicial sense. It did have a permanent bureau, a secretariat to manage logistics, but the judicial element was completely ad hoc.
You mean what, exactly?
Meaning when two states agreed to use the PCA, they appointed arbitrators case by case from a pre-approved pool of experts. There was no standing bench of judges, no inherent continuity of jurisprudence. It was an arbitration mechanism dressed up in a court's clothing.
So it laid the groundwork. It established the idea of a fixed location and a process, but the judges themselves were ephemeral. That structure proved insufficient once the world witnessed the catastrophic outcome of World War I.
Precisely. The staggering human cost of WWI made the need for a standing, permanent, international judicial body. Well, undeniable. This led directly to the creation of the League of Nations, and Article 14 of the League's covenant specifically mandated the establishment of the Permanent Court of International Justice, the PCIJ, in 1920. This was the ICJ's direct parent.
And the PCIJ solved a crucial organizational problem that the PCA hadn't even tried to address. How do you select permanent judges who represent the entire globe?
That was the foundational achievement of the PCIJ. Its statute resolved that really contentious issue of judge selection by establishing a sophisticated electoral process. Judges were elected simultaneously by the League's Council and the Assembly. This ensured that both the great powers and the smaller nations had a say. An electoral mechanism the ICJ still employs today, by the way.
When we look at the legacy of the PCIJ, What are the lasting innovations? The things that defined international law for the next century? Give us the quick hit list, but with some context.
Okay, so there are three major innovations that directly underpin the ICJ. First, the permanence. It was a truly permanent judicial body. It had a permanent registry, standing procedures, all ensuring continuity and consistency in its administration and its jurisprudence.
Which is key for building trust among states.
Right. Exactly. Second, transparency. Its proceedings, the pleadings, the oral arguments, the documentary evidence were largely public. This openness fostered legitimacy, demanding that states articulate their arguments legally and transparently rather than relying on, secret political maneuvers.
And the third point, which our sources highlight as critically important for the development of international law itself.
That's the codification of the sources of law. The PCIJ statute was the first legal document of its kind to explicitly list the sources of law the court would draw upon. These sources, international conventions, international custom, and the general principles of law recognized by civilized nations, were codified in what is now Article 38 of the ICJ statute. They essentially became the authoritative definition of what is international law, a rulebook the world still operates by.
That is foundational. Now here we hit a fascinating contradiction, the American paradox. The United States was instrumental in drafting this entire legal architecture, yet it never joined the PCIJ.
Why? It's a recurring theme in U.S. history, isn't it? The conflict between internationalist ideals and isolationist political instincts. Despite strong support from 5 successive presidents, Wilson, Harding, Coolidge, Hoover, and Roosevelt, the U.S. Senate never managed to get the required 2/3 majority to ratify the treaty.
Just couldn't get it over the finish line.
Never. Isolationist sentiments, fears of losing sovereignty, a general reluctance to bind the U.S. military and foreign policy to an international tribunal, it all just prevented membership.
So the nation that provided the blueprint for the World Court ended up standing outside, just watching it operate. That political hesitation, that tension between sovereignty and international obligation seems like a perfect foreshadowing of the enforcement issues the ICJ would face later on.
It absolutely is, especially with the U.S. in the 1980s. That failure to join the PCIJ established a precedent that international justice could be designed by great powers, but ultimately rejected by them when it came time to submit to its authority.
The PCIJ, though, was ultimately a casualty of the Second World War.
Yes. It held its final public session in late 1939. By 1945, when the Allied powers met at the San Francisco Conference to create the United Nations, they decided a clean slate was necessary. They opted to dissolve the PCIJ and establish an entirely new court, the International Court of Justice, as a principal organ of the newly formed UN.
But they kept the rulebook.
They did. To preserve judicial continuity, the ICJ statute is based substantially on the PCIJ's. The ICJ took over the judicial infrastructure, even occupying the very same building, the Peace Palace in The Hague. This makes the ICJ the only principal UN organ not located in New York City, which is perhaps fitting given its unique mandate.
The court officially opened its doors in April 1946 and got plunged into a major dispute almost immediately.
Indeed. Its first case was submitted in May 1947, the Corfu Channel case between the United Kingdom and Albania concerning maritime mines and state responsibility. Since its inception, the court has entertained 201 cases as of September 2025, and it conducts all its work, publishes all its judgments, and hears all arguments entirely in its official working languages, English and French.
That sets the historical scene. We now move into what is arguably the most politically fraught aspect of the court, its composition. I mean, how do you select 15 impartial judges that somehow represent the globe without simply becoming pawns of their home nations?
And this is where the tension between law and politics immediately surfaces. The ICJ bench has 15 judges, elected to staggered 9-year terms. The election process is deliberately designed to force a consensus. It requires a majority in both the UN General Assembly and the UN Security Council, voting independently. 5 judges are elected every 3 years to ensure continuity, so you never get a complete turnover.
But the selection isn't purely based on legal merit. The statute imposes a mandate that forces geopolitical consideration.
Precisely. Article 9 is the legal anchor for this political reality. It demands that the judges must represent the main forms of civilization and of the principal legal systems of the world. This has been interpreted, and this is critical, to mean a balance of common law, civil law, socialist law, and Islamic law traditions. You can't staff the bench exclusively with, say, U.S. and French jurists.
And this translates into a deeply political, informal geographic distribution that the UN membership adheres to. even though it's not strictly written down anywhere.
It's an unspoken covenant among nations. Informally, the seats are distributed like this: 5 seats for Western countries, 3 for African states, 2 for Eastern European states, 3 for Asian states, and 2 for Latin American and Caribbean states. This quota system ensures every region has representation.
And this is where the permanent members of the Security Council, the P5, the US, UK, France, China, and Russia, have traditionally exerted their influence, often making sure they always have a seat at the table.
Historically, yes. The P5 have reserved 3 of the Western seats, 1 Asian seat, and 1 Eastern European seat for themselves. This has been the geopolitical norm since 1945. But our sources highlight 2 major recent shifts that suggest global consensus, particularly within the General Assembly, is starting to push back.
Okay, let's discuss the first major crack in that P5 judicial armor.
Yeah.
The UK loss in 2017.
This was seismic. The British judge, Sir Christopher Greenwood, was supported by the Security Council, the powerful body where the UK holds a veto. But he failed to get a majority in the General Assembly, where every nation has 1 vote. In a dramatic display of General Assembly muscle, the seat went to the Indian judge, Dalveer Bhandari, instead.
That's fascinating. So the General Assembly, which the P5 often views as a less important consultative body, actually denied a permanent member their customary seat. That signals a shifting power dynamic, doesn't it?
It signals a profound shift. It was the first time since the court's founding that a P5 member lost its traditional seat. It demonstrates that the informal geographic quota is no longer solely dictated by the Security Council. It means countries outside the P5 can successfully lobby the General Assembly to prioritize emerging regional powers.
And the second shift is even more recent and geographically specific.
Right. Starting in 2024, for the first time in the ICJ's history, there will be no judge from Russia or the Commonwealth of Independent States occupying the Eastern European seat. This loss further underscores that customary seats are not guaranteed. They are subject to the political scrutiny and majority vote of the General Assembly.
Shifting to another aspect of representation, the source material notes the severe lack of gender diversity.
It's a point of serious and warranted criticism. In 77 years, only 5 women have been elected to the court. While the court has made strides in geographical representation, gender representation lags severely behind, raising ongoing concerns about whether the bench truly represents the main forms of civilization if half the world's population is largely excluded.
Now, setting aside the geopolitics of who is elected, what are the rules designed to maintain the judge's impartiality once they're on the bench? Because independence is the cornerstone of justice.
Absolutely. Judges must be of high moral character and qualified for the highest judicial office in their home states. Critically, Articles 16 through 18 impose structural independence. Article 16 strictly prohibits judges from exercising any political or administrative function or engaging in any other professional occupation. They have to be full-time, independent jurists.
And they can't be biased by their past work on a case.
Correct. Article 17 requires independence from prior conflicts of interest, meaning a judge cannot participate in a case where they have previously served as counsel or advocate for one of the parties. Furthermore, a judge can only be dismissed by a unanimous vote of the other members, which makes removal nearly impossible and thus reinforces their independence from political pressure.
But even with these strict rules, the independence of ICJ judges is constantly questioned. And the sources confirm this, pointing to some concerning research about voting patterns.
They do. Research studying judicial decisions has found strong evidence that ICJ judges favor the state that appoints them. And this isn't just an anecdotal observation, it's a measurable pattern. But the critique goes deeper than simple national allegiance.
How so?
The research also found that judges tend to favor states whose wealth level is close to that of the judge's own state, and also favor states whose political system is similar to that of the judge's own state. This suggests that even these highly distinguished jurists are influenced by deeper structural biases.
So when a state brings a case before the World Court, they know going in that if there's a judge from a similarly wealthy, similarly democratic, or similarly autocratic state, that judge is likely to view the case through a sympathetic lens.
It compromises the ideal of pure, objective international law. And this bias is never more transparent than in high-stakes, politically charged cases like the 2022 ruling ordering Russia to suspend military operations in Ukraine, where both the Russian and Chinese judges publicly registered their dissent. They cast votes that align perfectly with their national political interests.
This brings us to the unique and often criticized system of ad hoc judges. You have 15 judges, but for a specific case, you might suddenly have 16 or 17. Why is this compromise necessary?
This is Article 31, and it's perhaps the most obvious compromise